Good afternoon, ladies and gentlemen. Welcome back. And again, let me, on my behalf, thank the organizers for inviting me here. It's wonderful to be, for the first time, at Max Planck Institute Luxembourg. Now, what we're going to do this afternoon... Oh, right. My name is Jarna Petman. I am Deputy Director and one of the founders of the Erik Castrén Institute of International Law and Human Rights, and someone who comes from what is known as the Helsinki School of International Law. Now, what we're going to do this afternoon is to ponder on the nature and character of human rights that hold or have such a powerful hold of our imagination. When everything else seems to fail, when the formal and institutional standards are diluted into functional management, then we often hope that rights, at least, could bring us restoration of formalism, that rights, at least, could set limits to those who are in position of power making decisions. Rights indeed do have a very powerful hold of our imagination. And the reason that it is so, let me suggest to you, is that because they stand both inside and outside the political process that we are so afraid of. They are inside of politics, these human rights, in the sense that they are included and enshrined in conventions and constitutions that govern the everyday life in our democracies. As positive legal enactments, negotiated and formally agreed upon by states, by those who are indeed positions of power, human rights are concrete. They are verifiable. They talk the language of rules. But rights exist outside of political process as well, and to the extent that they hold that intangible promise of the universally good. That's something that is not reducible to political processes, to particular times and places. They are a promise of a brighter future, better world. And as such, they reach beyond the text of the rules, reaching towards the universal promise that went in the rules themselves. Now, it is this dual character, inside, outside politics, that makes rights so strong and accounts for their unimaginable power. And yet, it is that very fundamental nature of rights, that dual nature, that also injects a tension into the rights themselves. On the one hand, rights are very political constructions indeed, speaking to the everyday of that particular community that they come from. And at the same time, they are apolitical, ahistorical, universal constructions. These two tenets cancel each other out, they challenge each other. And it is because of this tension that the administration of rights is about discretion, compromise. And it is precisely this discretion that for us so often seems to lapse to failure that we will now be pondering on this afternoon in various different ways. We have 5 brilliant young scholars looking at the various ways in which rights fail to deliver and at the same time keep us hoping. Now, for the first speaker, well, we have here Michel, Nicolas, Oliver, Atanasio, and Dalia, who will all in their different ways address this very issue. For the first speaker, and all of them, by the way, I'm very aware of the 15-minute limit, and given the fact that this is a full-packed panel, I will be firm, I will be fair, but I will be very restless if you start getting beyond the 15 minutes. Now, Michel, who is, I should note, one of the very few people in the room who is actually from Luxembourg, and is now a research fellow here at Max Planck Institute, is just about to finish his PhD. Congratulations already are in order. And he's doing his PhD at Paris 1. Now he is very much looking into the history of human rights in his current work, in his PhD, and that is his interest that will, I think, keep him looking into the history of human rights in the years to come. He has been trying to resurrect, especially those human rights regimes that have been forgotten. And that indeed is something that we will now be looking into for the first 15 minutes of our panel. Please, Michel.
So, thank you very much. Thanks for having me here. So yes, I'm going to try to resurrect a forgotten jurisdiction of the interwar period, and there were many of those jurisdictions. But I'll focus on this one because it addressed minority rights and in some ways prefigurated what we do today in human rights, international human rights law. Technically speaking, the Upper Silesian Mixed Commission was not a failure. Its procedures were effective, its case law was pioneering, and it actually did something which many jurisdictions don't. It actually saved the lives of hundreds of people. And yet, it was utterly forgotten by international legal scholarship. And now with my presentation, I'll try to resurrect it a little bit. So, okay. So first, I'm going to present to you the general context of Upper Silesia during the interwar period. Then I'm going to talk about the legal framework which set up the Upper Silesian Mixed Commission, which was the Geneva Convention of the 15th of May, 1922. Then I'm going to talk about innovations that the Mixed Commission made, first in the procedural field and then in the substantial law. And lastly, I'm going to talk of the Mixed Commission as what French historians would call a non-lieu de mémoire, i.e. A space of collective amnesia of international legal scholarship and even of local historians maybe. So, the situation after, well, before the First World War, so you can see Upper Silesia, Lower Silesia. Upper Silesia was the most southeastern province of Prussia and also of Germany. It accounted for 20% of Germany's coal production at that time, and it was heavily industrialized, so extremely strategical. However, even though it hadn't been part of the Polish crown since the 14th century, it was mostly inhabited, or 60%, by Polish-speaking people, or at least people speaking Polish dialect mixed with German. Now, after the First World War, the Allies decided, under Article 88 of the Versailles Treaty, to carve it up, to give parts of it to the Poles and parts of it to the Germans. Now, to define the border, they held a plebiscite on the 20th of March 1921. The problem was that the outcome of the referendum showed that the carve-up would have to go, the linguistic border would have to go through what they called the industrial triangle. So you had all these industries. Imagine, I don't know, Lorraine or Luxembourg or the Rhineland, the Ruhr. And you would have to carve it up. Now, that would probably destroy all the industries because all these infrastructures were interconnected, railways, water, electricity, and also actual people, because on both sides of the linguistic border, you also had Polish Upper Silesia, had Germans, and in German Upper Silesia, you still had Poles. So they asked the League of Nations to come up with a plan because they were unable to agree on an exact carve-up because the British wanted to favor the Germans and the French wanted to favor the Poles. So the League came up with a plan, and this was that famous Geneva Convention of 1922, well, then famous, now not famous anymore. And when I'm talking about the League, that meant actually its then young Deputy Secretary General is somebody whom you all know, who was Jean Monnet. So Jean Monnet actually had the basic idea of that Geneva Convention. and it was fleshed out. I mean, the whole convention, the actual provisions were written by a conference team with 11 subcommittees, which was headed by a third national, the former Swiss president Felix Calonda, who was himself member of the Romanche minority in Switzerland. And so he was chosen for his conciliatory and mediation skills. He was assisted by, of course, by the League Secretariat, and most notably by Georges Kakenbeek, who was a Belgian jurist. I haven't found a picture of Georges Kakenbeek, unfortunately. So the 3 negotiation sessions were held between November and May 1921 and May 1922. First in Geneva, then, most interestingly, in Upper Silesia, which apparently relaxed the atmosphere a lot, so because the whole conference team was able to see the actual problems there. And finally, again, in Geneva, where it was signed and was seen, at least by the international lawyers of the period, as a triumph of conciliation, because Calonda, who had been given a casting vote, i.e. he could impose a solution upon the parties if they disagreed, he hadn't had to use that casting vote. Now, the convention itself, now it was the longest international treaty of that time. It was longer than the Versailles Treaty, 606 articles, and so in some sense it already is a prefiguration of the current EU or ECC treaties because of its length and of its technical detail, because it regulated 2 things. Firstly, and there was the main part, keep the industrial area, the industrial triangle up and running. So you had to actually limit Poland's ability to impose its own sovereign laws in that area. Otherwise, for instance, German workers living there would have lost, or German Polish workers, or Polish workers would have lost their social rights, or the railway connections would have been interrupted, etc. And so, for instance, parties agreed that Poland would be able to impose its own social legislation, but only if it had deemed fit by the international community. Secondly, guarantee minority rights, because you had Germans living on the Polish side and Poles living on the German side. And most interestingly, this treaty was the only interwar treaty, minority rights treaty, that was bilateral. So Germany and Poland, because normally these treaties were only between Poland and the Council of the League, for instance. They were not bilateral. Here they were bilateral between 2 countries. And this was also Jean Monnet's idea. They created 2 international bodies who were aimed at ensuring the effective implementation of the convention. Now, first, the Upper Silesian Arbitral Tribunal, headed by Georges Kakenbeek, which was competent for individual claims regarding vested rights and nationality. And it was also given preliminary ruling jurisdiction. So the ECJ's current preliminary rulings actually come from there, because it was Jean Monnet's idea. Then they also created the Upper Silesian Mixed Commission, which was competent for interstate disputes and minority rights. However, and this is the major downside of that convention, it was a provisional regime which was only to last for 15 years, i.e. until 1937. So, the Upper Silesian Mixed Commission was based in Katowice, or Katowice as the Germans would say, in a Polish Upper Silesia. It was headed by Felix Calonda, chosen by the Council of the League, but at the joint request of Poland and Germany. It also comprised 2 Poles and 2 Germans as members of the Commission, and 1 Polish and 1 German state representative, and they acted as intermediaries between the governments and the Mixed Commission. So its jurisdiction was twofold. It could issue binding decisions in various matters, including as a filtering instance for the PCIJ, also very interesting. And however, it only received 18 complaints by states, which didn't lead to a single decision. However, the advisory opinions its president could render in the field of minority matters led to more than 3,400 petitions and to 127 formal opinions, because most were actually led to conciliation. So, 3 minority rights procedures, because I'm going to talk about minority rights here. So the main one, 2 local ones, 1 before the League Council. The main one, so you had to exhaust local administrative remedies. Then you had to petition before local minorities office, so under national jurisdiction in Poland or in Germany. Well, there was one on each side of the border. If the Minority Rights Office didn't fulfill your demands or within 20 to 45 days, it would have to forward it to the president of the Mixed Commission, who would then be given wide evidentiary powers, and so he could summon witnesses or organize on-the-spot investigations, and he would render an opinion which would be forwarded to the states, and which had to report. The states would then have to report back, but they were not obliged, and this is really important, to actually conform to the opinion. And moreover, which also weakened the opinions, they could be appealed before the League Council, at least until 1933-34, because Germans and the Poles were not happy with the Council anymore. They left. The Germans left, and the Poles refused to comply. So, is this no up? Okay, sorry. So Callender actually did something we talked about this morning. Ingo Venske said he judicialized the procedure to make himself look stronger and to give himself more authority. So he wrote the rules of procedure, and he decided that each petition had to be given a motivated answer. He organized adversarial oral hearings in addition to the written phase, and he put petitioners on par with the state. Then he wrote his opinions, when he issued them, like judicial decisions. So he applied legal rules to facts, he made reference to his own prior case law, and he coached the operative provisions of the opinion in imperative terms. Now, he rendered 2,283 petitions. No, he received these petitions, he settled most of them, and he rendered 127 opinions under this regime. There was also a summary procedure that was actually totally invented by Callender, because the Article 585 of the Geneva Convention said that the president could draw the attention of the state representatives to facts, circumstances, or situations not in keeping with the Geneva Convention. And Callender simply transformed this into a new fast-track minority rights procedure. So you could send him a petition, and he would immediately notify the national authorities. And this was extremely useful during waves of violence, uprisings, for instance, but also after 1933 in German Upper Silesia, when the Jews were persecuted. And he treated almost 1,200 cases under this procedure. He also negotiated with the states so that each time he notified them with some facts, they would have to initiate criminal proceedings. And they did. And then there was finally the direct procedure in Geneva before the Council, which was so you could send a petition to Geneva, and the Council would have to examine it automatically. Now, this was a problem because it undermined Callender, because you could also, it undermined his authority, and Geneva was often not the right place to treat very mundane issues such as verbal insults in the street or school opening hours. So, because you had people like Aristide Briand who had to decide on matters like that, that was maybe not the right forum. Huh? So, but the advantage, of course, was when there was a serious matter, such as the persecutions of the Jews in 1933 in German Upper Silesia, and there the Council was a forum that could at least lead to more publicity, and was the case with the Bernheim petition of 1933, which led to the suspension of anti-Jewish legislation in that area until 1937. So the Nazis suspended their legislation in German Upper Silesia. Callender also developed a few principles that we still know today in international human rights law. Non-reciprocity, so if Poland violates the convention, Germany doesn't have the right to violate it either. Principle of most favorable protection. If there's a provision that's not clear, you have to interpret it in a sense that's favorable, most favorable to the minorities. Extended use standi for association. So minorities have the right to associate, to form associations, so they also have the right to send associations, send a petition to the Mixed Commission. And national security exception. So you might have the right to join, to use a minority right, such as joining an association, but you cannot jeopardize the state's sovereignty by doing that. For instance, you can't join a paramilitary armed group, which is nationalist and which would want to overthrow the local government. There was also some interesting case law on discrimination. So direct discrimination was always illegal. This was very useful after 1933 in German Upper Silesia, so Calendar's interventions also led to, together with the League Council, but also on his own account, led to the suspension of anti-Jewish legislation in that area. Also, private actions such as boycotts of Jewish stores or anti-Semitic publications were also banned by the German authorities, and individuals that had been dismissed on racial grounds were reinstated or compensated. So this actually allowed, as a local rabbi said, hundreds of people to prepare for emigration and to leave Germany before it was too late. Calander also said that indirect discrimination was illegal, so he gave a definition of it, an early definition of it, maybe even the earliest in international law. I might read it to you. So it said, discrimination exists not only when different conditions are imposed on members of the minority, but also when the conditions are the same from an outward point of view, yet in practice, owing to the factual circumstances, constitute a unilateral disadvantage for the minority. So after the war, I mean, the Mixed Commission was closed down as planned in 1937 because the states didn't want to renew the convention. And, but the members, the people that were implicated in this project wanted future generations to be aware of this experiment and learn from its experience, its positive and negative experience. So in 1938, Calander actually joined a German association of jurists founded by Hans Frank, you know, the future war criminal, to have his opinions edited in Berlin by one of the most leading scientific publishers. They were published in the fashion of the German Reichsgericht decisions of the Judge Supreme Court. So, and it was a critical edition and with an introduction and everything, so very, very interesting. In 1942, Georges Kakenbeek wrote a very detailed account of the international, what he called the international experiment of Upper Silesia, which was published by OUP. And in 1946, Marek Korowicz, who was the former head of the Polish Minorities Office, published chez Pédon, une expérience de droit international, la protection des minorités de Haute-Silésie, where he said that this was a model for future human rights bodies, whether national or international. And yet, only one author mentions the Upper Silesian Mixed Commission in his textbooks after the Second World War, and this is Paul Guggenheim, both in his German version and in his French version of his textbooks, but he and Calanders were friends, so they knew each other, and he talked often with him about the Mixed Commission, and that is why he included it as a significant precedent. Now, the Mixed Commission's building still exists in Katowice with the help of Lidia Sokolowska. I contacted them in Poland, and there's no plaque on it. I mean, there's nothing. Nobody knows about them. Even people at Katowice University were not really aware of this. So why this collective amnesia? There are three possible factors. I mean, these are only conjectures. First would be conflation, because the minority treaties were a failure. This is true, and most procedures were a failure. They didn't really work. Most authors forgot about the fact that the Upper Silesian procedures did work and saved people's lives. So this was namely the case of Georges Selle, who in 1934 wrote about it as a very interesting precedent, and in his second textbook in 1943, okay, maybe understandably because of the context, didn't even mention it anymore. Second would be mortification. I mean, after the Second World War, Wilsonian legalism, legal solutions for political problems was not en vogue very much. So this is, of course, a factor, and you wouldn't resort to minority protection, but rather to population exchanges. And maybe also the last one would be self-delusion, because nobody likes a memento mori. And maybe the court down the road or the court in Strasbourg, who are currently threatened, you know, in peril of death, wouldn't be very interesting in having such a memento mori on their, or plaque for the Upper Silesian Mixed Commission, or maybe a room named after it within their premises. Thank you very much.
Thank you very much indeed, Michel. Very interesting. Memento mori, indeed. That sent shivers down my back. Now, Nicolas Canriou will be the next speaker. He will actually be speaking about another nearly forgotten organ of which I was a member. Nicolas knows this. So I used to be a member of the European Committee of Social Rights. Now, when we are sworn in, we have to swear that we will not disclose any information, so I will not be commenting on. But I must say that, and I've already told Nicolas not to hold his punches, because like most relationships, my relationship with this particular committee is a complicated one. Now, Nicolas has defended his PhD in Strasbourg, where he became familiar with this particular committee. And his focus really is, and continues to be, human rights, not only social rights, but human rights more general. He is currently lecturing at Salford in Manchester. And right now, he will look into the success, or rather from limited success to the failure of the European Committee of Social Rights. So Nicolas, please.
All right. Thank you very much for inviting me as well. And I'm really pleased to be able to talk about the European Social Charter. As Jana said, there is a very limited scholarship on the European Social Charter, even if it's supposed to be as important, theoretically, as the European Convention on Human Rights. And I wanted to quote Jean-Claude Juncker, because we are in Luxembourg. And on the 14th of September 2016, on the discourse of the state of the European Union, he stated, we have to work urgently on the European pillar of social rights, and he said, Europe is not social enough, we must change that. Which is good. Which is good, but of course it's forgetting the role that the European Union has played. And I'm talking about the European Union because one of the points I'm going to make is that it's a major culprit in the way the European Social Charter has been undermined since 2008. And of course, also that statement overlooks the fact that the European Union is officially committed to social rights and has been for a long time. And that all the members of the European Union are also parties to the European Social Charter. Now, I'm going to concentrate more on the collective complaints mechanism because it was meant to revitalize the European Social Charter in the 1990s. Now, it was created, in 1995, entered into force in 1998, and the aim, according to the preliminary report, was to increase the efficiency of the supervisory mechanism, which was based solely on the submission of governmental reports. And as well, to increase the participation of trade unions and NGOs. So that's one of the ways we could look at whether the collective complaints mechanism has been a success or a failure. But that's only one of the ways I'm going to have a look at, because the other way, obviously, is to see what has been the impact of that collective complaint mechanism in the times where it was needed the most, since 2008. And as we know in terms of statistics, the general level of protection of social rights, and in particular in the states which have been subjected to austerity measures, are not nice to see. In terms of social exclusion, in terms of access to health, etc., etc. And there are Greeks here who could testify, I'm sure. So I'm going to look at 2 points. The first is that actually the collective complaints mechanism was undermined from the start. Arguably, it was a success because, on the first hand, well, it came into being. So that's one of the things which were mentioned this morning. Just entering into existence is a success. Many proposals never came into fruition. But of course, it cannot be enough to qualify it either a success or failure. There has to be more than just the existence of the mechanism. Now, as I said, the collective complaint mechanism was part of a broader aim to revitalize the European Social Charter, because there were 3 points which were thought not to function very well. The first one was that the supervisory mechanism of the European Social Charter was quite inefficient. Until between 1961 and the 1990s, the Committee of Ministers, which was supposed to have the final say as to whether the states had complied with the Charter provisions or not, well, never stated that the findings of the Committee of Social Rights were about a violation of the European Social Charter. So the comments at that time, in the 1990s, of the European Social Charter, one of the leading professors said that he was living a twilight existence. And so 3 responses were made. One is to change this supervisory mechanism, which was done through an amending protocol, which, by the way, has never entered into force. It was signed in 91, but 4 states have refused to ratify it: Germany, Denmark, Luxembourg, and the UK. So that was one point. The second was to update the rights contained in the European Social Charter, which led to the revised Charter of 1996. So that was successful, except that we still have many states, including states of the European Union, which haven't ratified the revised Charter. And then we had this collective complaint mechanism. The idea there, the main focus, was to make the stakeholders, primarily seeing the trade unions, to engage more with the European Social Charter, because they were seen as the groups which had the most interest in defending the social rights. Now, what happened in the implementation of the collective complaint rules is that it's embodied or integrated all the things which were at the beginning of the ECHR, meaning it's not compulsory, so every state has to choose to abide or to accept the collective complaints mechanism. And at the moment, only less than a third of the member states of the Council of Europe have done so. That's 15, so that's not many. And even within the construction of the collective complaint mechanism, there are a lot of limitations. Basically, only 72 NGOs have the right to bring a collective complaint to the European Committee of Social Rights. It's only if the state accepts a further, to make a further declaration that all the NGOs in the state can bring a complaint if they are active in the area. And only Finland has done so far. So inbuilt, we have a lot of mechanisms to make sure that only states which really want to participate will do. And as we can see, very few have. It has led to a quite limited number of applications over the year. Now, there had been expectations that it would grow, that it would be the same as for the European Court of Human Rights, that was progressively built up, except it hasn't. There has been 119 complaints from the 1st of July 98 until the end of last year. And in 2005, 6 new collective complaints. So the numbers, there is no upward trend. So in the way it has been designed, it's been designed to, well, not to be similar to the ECHR, at least. It's been designed to cope with a limited real acceptance of the member states towards social rights, which has led that actually it is possible, and it is, according to what I've read, acceptable even for some states to ignore what the conclusions are of within the collective complaints. Now, the Committee of Social Rights has used the vocabulary to mimic the judgments of the European Court of Human Rights. So the way it's structured as a judgment, and with findings of violations. Now, the states then have to say what they have done in order to comply. Now, what we see in reading this, the follow-up, which is an interesting element of the collective complaints, is that in many instances, it's okay for the state not to do any action and not even to communicate about it. And I'm not talking only about the states which, well, including them is France, and supposedly has a stance on social rights which is positive towards them. So we have 10 instances where states, when they have been condemned or found to be in breach of the European Social Charter through a collective complaint, haven't said anything about it. So they have completely ignored the system. Now, for most of them, the states have taken a few steps, but for most, the committee finds that the state is not in compliance. We have only, in the ones that I've seen, only 3 instances where the committee has found that the state has fully complied with the findings within the collective complaint decision. So, to summarize on this point, the states it's easy for the states, at least, to ignore what the conclusions are of the collective complaints mechanism. It is not to say that it hasn't done anything. For instance, in the context of the Roma rights, arguably, states have been pushed to transform some of the provisions to cater with the rights of the Roma population. But when we are looking at the major issues of the problem of social rights within Europe, the fact is the responses has been very poor. And that will be my last point, is that the system itself has been undermined by an maybe unlikely actor, but if we look at the European construction, maybe not that unlikely, it's the European Union. Of course, the European Union is not a member of the Council of Europe, and there is no provision for the European Union to adhere to the European Social Charter, contrary to the European Convention on Human Rights. But what the European Union has done, clearly, in the context of the austerity measures taken in Greece, or in Spain, or in Portugal, the European Union, through the Troika actions in Greece, has directly or indirectly imposed measures which have undercut the access to social rights in many circumstances, in particular in Greece. Now, interestingly, the Greek trade unions have made several complaints through the collective complaints mechanisms. And the committee has responded positively and has found many breaches of the European Social Charter in a series of decisions. Then what happened? Well, what happened is that Greece, in the follow-up, has said, well, we are unable to comply because of our other international obligations. And obviously, they were pointing towards the obligations stemming from the agreement with the Troika. And they are very happy, well, at least in the official documents, they are very happy to state that it is sufficient. So maybe in the future, they will comply, but for now, they can't. And the Troika obligations take precedence over the obligations under the European Social Charter. What of course, the committee hasn't accepted that it was a good enough excuse not to comply with the European Social Charter. But if we look at what the Committee of Ministers has done, well, it hasn't done much. And if you look at what the other European institutions have said about the situation in terms of social rights, well, it's the same, but for the European Parliament. The Commission has recently done a survey as to the impact of the last agreement with Greece, and it hasn't mentioned the European Social Charter. It was supposed to see the impact on social rights. It hasn't mentioned the European Social Charter. So, if we were to take a cynical view, well, the European Union doesn't care really about social rights. All the European Union members, when they are part of the European Union, completely forget that at the same time, they are members of the European Social Charter, members of the Council of Europe, and that when they are in the Council of Europe confines, they are all saying that the European Social Charter has to be revived, has to be reinforced. That's the declarations we see on a consistent basis. And in the last 2 years, there's been a series of meetings organized in order to increase the efficiency of the mechanism. So the same states within the Council of Europe are saying we must do more to support the European Social Charter, but when they are members of the Eurozone, they completely forget about these obligations. So, if you take the perspective of the audience, as was suggested as one of the possible ways to assess if a mechanism is a success or a failure, then from the perspective of the audience of the population in Greece, in Portugal, in Spain, probably you would call it a failure. If you see it as a way of redress, it isn't. Now, if you see it as a way to develop the law on social rights, so maybe you could argue that the committee has done a lot, and it has, actually. But it has largely been ignored by the rest of the doctrine. Barely, well, there are very few academics who study the European Social Charter, who publish about the European Social Charter, except for the former members or the members of the committee itself. So maybe Anna will publish. So what about next? Well, it's very difficult to see a next as long as within the confines of the European Union, the position of the member states stays the same. There is no reason to see any changes. Even if Jean-Claude Juncker said, we must reinforce the social rights within the European Union. And arguably, according to Paul Krugman, or probably you know the name of a Nobel Prize winner in economics, and for him, the strongest culprit in the reason why the social rights have been so undermined since 2008 is the Eurozone, is the mechanisms of the Eurozone, which are at the top of the list of the priorities of the Eurozone members. And social rights there, they don't count. They don't matter. They are completely forgotten, ignored. So, is there a future? I don't know. For you, to tell me. And so, on that side, it's quite easy to say that at least it's a partial failure. Now, obviously, it's possible to have a different take on the history of the collective complaint mechanism, but that's the one I've taken today. Thank you.
Thank you very much indeed, Nicolas, for reminding us that perhaps even more important for the rights to survive is not as much recognition of rights than the interpretation that those rights are given. And the fact that social actors, civil society especially, takes up and uses those rights. Now, next, we will have Olivier Barcelou, who comes, well, he's defended his PhD at NYU, but has since then returned to his hometown. He's now at McGill, working on history of human rights. And as was earlier noted by Bardo, very much this conference is about history. Regardless of the grand title of each panel, we tend to dip deep into the history, as we will now. And Olivier will look into the interpretation of peace treaties and possible, potential, perhaps failure thereof, with a question mark.
Hello, everyone. Hope you are doing well. I'd like, first, before I start, I'd like to thank the whole team here at the Max Planck Institute, the whole team in this room, and the whole team outside this room. I think they've done a marvelous job, so I'd like to thank them all for that. And also, thanks for taking the courage to put me on board. It's very much appreciated. Today, I'll try to take another 12, 15 minutes, not so much, to talk about a case law from the ICJ that probably no one has read, and probably if you have read it, you probably don't remember it. It's a 1949 interpretation of peace treaty with Bulgaria, Hungary, and Romania case. So it's a personal story, and it's a legal history. So but above all, it's a tale of two debacles. The first one is personal, and the other one is legal, more serious. But I'll start with the personal debacle. And I'm sorry, at the outset, I must say, I'm with the shameless name dropping that's coming, but it's just to put you in the mood for the story I'm about to tell. So almost 10 years ago, I started my LLM studies at NYU, and I was very privileged. I'd been selected to be one of Professor Thomas Frank's research assistant, and it was an honor, a real honor for me to have been selected by such a highly regarded international lawyer. And in our very first meeting, I remember, it was about 10 years ago, like day for day, he asked me, and it's no joke, Olivier, which topic would you like to research under my guidance? And I nervously mumbled, and my English was terrible back then, Marco can testify. And I nervously mumbled, I said, Professor Frank, well, I think there's something that needs to be said about the 1949 advisory opinion on the interpretation of peace treaty with Bulgaria, Hungary, and Romania. And then, for those of you who know Professor Frank, he's sitting in behind his desk and was just like rolling his thumbs and said, uninteresting. And so I'm going to talk to you just right about that today. This case is a case of legal debacle. It's a legal debacle. And then I looked at, because the title is very fascinating, because I look into the word debacle. At home, there's a river flowing, and we have a debacle every spring. So it means when the ice breaks and the river, the flows of the river is freed. And here the debacle I want to talk about is a debacle about a missed opportunity. This is a missed opportunity because the 1949 advisory opinion, I think, was a great moment, albeit unseized back then, but a great moment for the post-war emerging human rights system. And I think the International Court of Justice and all the states involved in this case missed that opportunity. It's a debacle, but on the other hand, it was an embacle. In the sense that the case contributing to jamming and stifling the development of human rights after the Second World War. And just for instance, everyone knows, but it took almost 20 years before reaching an agreement over the Human Rights Covenant of 1966. But the ICJ could have taken a stand in this debate and the emergence of human rights. But I'll get back to that in conclusion. So my approach, I'm looking at it from the perspective of the American government archives. So for past years, I spent weeks and weeks, too many weeks of my life, digging into the Roosevelt and Truman presidential archives, Department of State archives, Archives, Department of Justice Archives in Washington, New York State, New York City, and Independence, Missouri. So please just never go there. But it's fascinating, and I found like a few interesting things in these archives. But before I start talking about this case specifically, I just want to offer you like a few contextual reminders. The case was decided in 1949. So between 1945 and 1949, lots happened. First, and I'm just providing a quick overview. First, and it's really, really, really important for that history, if you want to tell it at length and contextualize it correctly, it's the rising Cold War tension. And it's fundamental for all international lawyers involved in this case, above all the American lawyers involved. I'm thinking of Charles Fahey, John Dulles, but Philip Jessup, for instance. And when I'm thinking of, when I talk about rising Cold War tension, I'm thinking of the division of Germany, the first Berlin airlift, 1948, the Marshall Plan, and the communist seizure of power in Czechoslovakia. So there was a lot going on, and Chinese Civil War, the Soviets working on the atomic bomb, and so forth. So there was something going on there around 1948, 1949. 1948, December 8, 1948, adoption of the Universal Declaration of Human Rights, a fundamental document in the history of human rights, and yet it's important for my story to note that the communists abstained from voting on the document. So here, the declaration embodied some sort of Cold War divide within the very text of this emerging human rights system. Third contextual reminder, the Americans, it's not about the Cold War, US rising Cold War anxieties, and they were nervous, really, really nervous. Above all, they feared, this is what I found in the archives, they feared national and global communization, the colonization of national and international legal system by communist IDs. And it was a real threat, concrete threat, at least in the minds of legal advisors in the US. And the fourth element, and then I'm moving on to the treaty, is the trigger. The arrest of Cardinal Mincenzi in Budapest and Archbishop Stepinac in Zagreb. Two high-ranked clerics in Eastern Europe. They were arrested, tortured, and they were imprisoned for several years. But these two clerics became symbols of the political and religious cleansing going on in Eastern Europe under communist power. Imprisonment, disappearance, torture. And this situation compelled Catholic Jewish organization to file grievances with the US government and asking for help. So this is the context, 1945, 1949. So the treaties, well, the Paris Peace Treaties are, well, they're probably better lawyers here than me, but there are quite regular treaties, post-war treaties. There's a series of treaties, very similar in shape and substance, concluded in Paris in the summer of 1947. So in that sense, they are quite banal. They end the war between the United States and the Allied powers on the one hand, and on the other hand, the Eastern European countries that fought on the side of the Nazis, Romania, Bulgaria, and Hungary. But they're very banal for just one exception. And this is a really, really important exception because, just as a reminder, we're 18 months away from the adoption of the Universal Declaration when we are concluding these treaties in the summer 1947. And this exception is the Common Article on Human Rights, which stated that the countries, and I quote here, shall take all measures necessary to secure to all persons the enjoyment of human rights and of the fundamental freedoms, including freedom of expression, of press, of publication, of religious worship, and so forth. So there's an express provision regarding human rights prior to the adoption of the Universal Declaration of Human Rights. So in that sense, with the UN Charter, this is like quite a progressive document to some extent. But yet, the situation in Eastern Europe, as I said, the religious and the political persecution on a large scale, triggered global uproar at the Vatican, in Western Europe, in the United States, in Latin America. at the United Nations General Assembly in New York City, Australia and Bolivia, among many other countries, took the lead on these issues within the General Assembly. And this translated in 1948 in the United Nations General Assembly asking the International Court of Justice whether there were human rights violations. I don't have the exact quote from the resolution, but the resolution is specific and is highly specific. It focuses on the human rights violation. And here, this is where it gets interesting. At the United Nations General Assembly, we're talking about human rights violation, and then the ICJ takes over the case. And now what's going on there? Well, at the ICJ, the United States, this is an advisory opinion, but still states submitted, like the United States, submitted memorials, even offered oral arguments before the court, whereas the Eastern European countries and Soviet Union didn't even dare to send representative there. But the US took the leadership, and yet, and what's interesting, if you read the archives, they never invoked either the human rights clause of the Paris Peace Treaty, nor the Universal Declaration of Human Rights, which was being negotiated in the UN. So it's interesting. It's a case about human rights, but we don't talk about it at the ICJ. And why? Because this is really fundamental. I think, why? Why did they avoid talking about human rights? For the US, there was a clear fear, and it's clear from the negotiation process of the Universal Declaration, they feared that this human rights document might colonize the US legal system and destroy the federal structure of the American constitutional system. And it was like, it's explicit in the document. And also, and this is another interesting part of the story, they didn't want to be targeted for violating the rights of colored people by attacking other nations. And so the thing is that you did something wrong, but we won't say it loud because we don't want to be attacked in return. And so that was the Western version of the story led by the US. On the other side, there was a deaf dialogue going on. Because the Eastern European countries, if you look at the diplomatic exchanges going at that time, it's fascinating. It's a deaf dialogue because the Hungarian, Bulgarian, and Romanian government said, well, they had abolished all discrimination. There was no more discrimination in these countries. I mean, the constitution had been modernized, and thanks to the new constitutional provisions, there was no more discrimination in these countries. So on the one hand, the US feared being criticized. On the other hand, everything was fine. And so this is how the case moved on at the ICJ. And what's interesting, and the American did a special trick here, because it's important. Hungary, Romania, and Bulgaria were not yet members of the UN. So the UN Charter Human Rights Provision, Article 55 and 56, couldn't apply. The Universal Declaration of Human Rights, even if it was in progress, couldn't be invoked because against these states. So what the American did, and it was perfect for them, is they say, well, we would like to have an opinion, but not on the issue of human rights violation, but whether we wanted to know whether there had been a treaty violation. And so here, this is the switch in the language, in the memorial, in the pleadings, and within the diplomatic exchange between the US and UK, the US and Australia and other Western countries. The problem was framed not in terms of human rights, but in terms of a treaty violation. And it makes a big, big, big difference. And it made such a big difference that even in the court, the International Court of Justice didn't rule on the issue of whether there had been human rights or there were human rights violations going on in Eastern Europe, but on whether there had been there was a dispute between the states involved in the case. And of course, the court concluded, well, there's a dispute here, and that was pretty much it. And so the Americans here, the argument they made was perfect. But because on the one hand, they show their commitment to defending, promoting human rights on a global scale. They did it. But on the other hand, the ruling excluded any discussion on the emerging human rights system. And it kept, I think in my opinion, the emergence of the system at bay. And so this is the story, the hidden story I think one can find in this case is a case of human rights stifling or human rights debacle, thanks to the ICJ. And so, in conclusion, what the archives are showing is that the emergence of the human rights system after 1945 was not so much a response to the Holocaust, as we normally think. It was there in 1945, 1948, 1949 was not the case anymore. We're not looking back, we were looking forward. We were thinking about defining the political and the ideological contours of the emerging world order. And what's the most interesting, and this is probably just like something, a rock I'm throwing on the pond here, but I think we could have discussion about that, is that human rights and the International Court of Justice emerged in 1949, not simply as laws, norms, or institution, but as sites where the Cold War could be waged. A Cold War for the hearts and minds of millions and millions of people could be waged. And so this history, I think, and I want to conclude here on this, still rests with us. And as a postscriptum, I have a tip to young scholars. Don't always listen to your advisors. If I listened to Professor Frank, I wouldn't be there today with you. And just one word to people who are advising young students here, I'm sorry. Thanks.
Thank you, Olivier. Here, an apology accepted. We will continue scrutinizing the dubious role of International Court of Justice with regard to human rights when Athanasius will take his floor. Now he comes, Athanasius Chouliaris, trying, who is a postdoctoral fellow in Athens and is really an international criminal lawyer, I guess. And also philosophy of law, sociology of law have been very much influencing his work in these fields. And hence, colored with these various fields of law, he's now looking at the role of International Court of Justice when it comes to the state responsibility in heinous human rights violations. So please, Athanasius.
Thank you. I would like to thank Max Planck Institute and, of course, the people here, Professor Elena, Lorenzo, and Simone, for inviting me and arranging all practicalities, and, of course, for their hospitality. So, it is a commonplace in international theory that the occurrence of core international crimes entails both the responsibility of the state in the name and at the behest of which they are committed, and the responsibility of the individuals who perpetrate them, materializing a lethal state policy. The concurrence and complementarity of these two separate regimes of responsibility is acknowledged by international law as well, although without further clarification on their precise relationship, which is left on the gradual development of customary international law. What is more, the principle of the duality of responsibility was confirmed by the ICJ in the case of Bosnia and Herzegovina versus Serbia and Montenegro, a finding that was also reiterated in the recent case of Croatia versus Serbia, 2015. The position on the concurrence of state and individual responsibility for the commission of core crimes stems from the fundamental acknowledgement that in both cases, similar primary international rules are violated, establishing equivalent obligations to states and individuals. In other words, the individual conduct or the state policy under judicial scrutiny infringes identical rules, given that in both cases the same legal interests are protected, bearer of which is the international community. As a result, a direct legal relationship is instituted between the delinquent state or the criminal individual on the one side and the international community as a whole on the other, aiming at the determination of the responsibility of the former. both forms of international responsibility, subsumed to the broader issue of the accountability of international actors for a conduct or policy evaluated on the basis of certain international standards, which is potentially punished or sanctioned in the case of concurrence found between the former and the latter. Finally, with respect to the nature of each form of responsibility, it is well settled both in international theory and practice that the commission of core crimes entails the criminal liability of individuals and the international responsibility of states, which is of course not criminal. Accordingly, it should be stressed that in the latter case, a special regime of responsibilities provided for Articles 40 and 41 of the draft Articles of Responsibility of States, based on the emergent and acknowledgement of two categories, the norms jus cogens and the obligations erga omnes, which is supposedly more aggravated in comparison to the ordinary regime of responsibility for the commission of the other international wrongful acts provided for in Articles 28 to 39. In what follows, I will argue that the ICJ has failed in the aforementioned two cases to materialize its allegations that there is a dual regime of responsibility for serious violations of human rights and genocide in particular. So initially, I will briefly revisit the work of International Law Commission, focusing on the provision of a special regime of state responsibility for the violation of jus cogens norms, and examine what were the initial intentions, what was the final outcome, and whether the latter serves the former or undermines the former. Afterwards, I will examine the method adopted by the ICJ in adjudicating whether the commission of genocide could be attributed to a state. Now, it is well known that the codification of the law of state responsibility lasted almost half a century. It started in 1953 and it was concluded in 2001. Very important dates are 1976, when the distinction between international crimes and international delicts was formulated, and 1996, where the draft articles were adopted on first reading, including the former Article 19 that provided for the aforesaid distinction. In particular, in 1962, the Commission decided to set up a subcommittee of state responsibility chaired by the Italian Roberto Ago, which was charged with the endeavor to determine the future work of the Commission in the field of the codification and progressive development of the law of state responsibility. The subcommittee decided unanimously to give priority to the definition of the general rules governing the international responsibility of the state, also known as secondary rules, and not to tackle the issue of the primary rules, that is the substantive rules of international law that incorporate the international obligation of states, such as with respect to the use of armed force. This technical decision was crucial for the work of the Commission for two reasons. Firstly, because the codification of the entire body of the primary rules, included in all sources of international law, would involve a titanic enterprise with no clear endpoint, whereas the codification of secondary rules was something achievable due to their generality and the fact that they can allegedly be studied independently of primary rules of obligation. It should be noted that the next special rapporteur, the Dutch Rifangen, further extended the distinction referring to the tertiary rules that concern the implementation of the secondary rules. No such rules were included in the draft articles. In this context, the Commission, following the proposal of the Special Rapporteur Ago, reached two conclusions. First, the subject matter of the international obligation breadth is not important for the characterization of such a breach as an international wrongful act of a state, and on the other hand, the subject matter of the national obligation breadth has an undeniable bearing on the definition of the regime of responsibility attaching to the internationally wrongful act constituted by the breach in question. These fundamental conclusions led to the distinction between international crimes and international delicts provided for the former Article 19 in paragraph 1 and paragraph 2, as it was adopted in 1996 on first reading, and to the statement of the criteria on certain criteria. Now, although the Commission did not explain what would be the result of such a distinction, it gave a clear sign, because that would be treated in the following part, referring to the content, forms, a degree of international responsibility. It gave a clear sign of its intentions, commenting that, and I quote, "It would be unfortunate if the Commission falsely gave the impression that it considers the regime of responsibility prescribed by general international law to be the same for all international wrongful acts. General international law now differentiates between various types of international wrongful acts and consequently between various regimes of international responsibility. Accordingly, the codification of general international law entails the definition of those different kinds of wrong and the determination of the corresponding regimes of responsibility. Therefore, it is safe to claim that the above-mentioned distinction was a necessary first step for the institution of a special regime of state responsibility for the commission of international crimes of states." Based on the written comments of various states to Article 19, one could trace two main tendencies. The majority of states, although formulated reservations about the use of the term criminal due to the connotations provoked, seem to be favorable to the distinction between international crimes and the international delicts on the basis of the importance of the obligation breached for the interests of the international community as a whole. Some states, on the other hand, reject such a distinction, considering that it would inevitably result in the provision of a criminal responsibility of the states, which is not acceptable. As it is well known, Article 19 did not survive on second reading. The next special rapporteur, Crawford, characterized it as the most controversial aspect of the draft articles, highlighting, on the one hand, various technical deficits in the wording of the article, and on the other, the significant consequences of international crimes, which were basically two. Under the former Article 40, paragraph 3, all states in the world are defined as injured states with respect to an international crime, and two, under former Article 53, there is a limited obligation of solidarity in relation to crimes. By contrast, the draft articles do not provide for punitive damages for crimes, let alone for other sanctions. Nor do they lay down any special procedure for determining authoritatively whether a crime has been committed or what consequences should follow. This is left to each individual state to determine as injured state. Detailed proposals for such a procedure were rejected by the Commission in 1995 and again in 1996. Attempts to draft lesser alternative procedures were not accepted. Overall, it can be said that the specific consequences attached to international crimes in former parts 2 and 3 of the draft articles are rather minimal, at least if the notion of crimes reflected in Article 19 is to be taken at face value. In this context, the draft articles adopted in the second reading in 2001 refers in Article 40 to a serious breach by a state of an obligation arising under a peremptory norm of general international law, which has as a consequence, A, states shall cooperate to bring an end through lawful means any serious breach within the meaning of Article 40. B, no state shall recognize as lawful a situation created by serious breach within the meaning of Article 40, nor render aid or assistance in maintaining the situation. And C, any state other than the injured state is entitled to invoke the responsibility of another state if the obligation breaches onto the international community as a whole. All in all, the draft articles contain no tertiary rules relating to the implementation of secondary rules of state responsibility. This latter is not criminal in nature, even when serious breaches of state of obligation arising under peremptory norms are at stake. It is difficult to envisage what really differentiates such a special regime of responsibility from the ordinary one. Now, turning to the work of ICJ. In both cases, the basis of jurisdiction is Article 9 of the Genocide Convention of 1948, which clearly states that disputes between the contracting parties relating to the responsibility of the state for genocide or for any other acts enumerated in Article 2 of the Convention shall be submitted to the ICJ at the request of any of the parties to the dispute. Beyond the reference to state responsibility, resulting from the fact that genocide has been committed in modern history in furtherance of state policy, the rest articles render clear that two are the main goals of the Convention. Criminalize genocide and punish its perpetration within the legal system of each party, and accordingly provide for the judicial cooperation of those contracting parties for the suppression of the crime. It thus seems clear, both from the text of the Convention and the preparatory works, that the Genocide Convention is very much like some previous international treaties, such as the 1929 International Convention for the Suppression of Counterfeiting Currency, or the most recent Convention Against Torture of 1984, which provide for a set of international obligations for contracting states are required to implement with their own domestic legal systems, and in addition to arrange for judicial cooperation in the matter regulated by the treaty. In other words, the Genocide Convention was drafted in order to prevent genocide as an instance of individual criminality. In 1948, and subsequently, states consistently steered away from the notion that they themselves might be held criminally responsible for genocide. Nevertheless, Article 9 inappropriately refers to Article 3, paving the way for the application of criminal law categories valid only for individual conduct and not for state action, that is, conspiracy, incitement, attempt, and complicity. This natal deficit of the Genocide Convention is further exacerbated by the methodological choice made by the ICJ to transpose criminal law concepts to the corpus of international law of state responsibility instead of employing different ones. The most characteristic examples are the standard of proof used and the demand for the establishment of a genocidal intent. More in particular, when dealing with violations of Articles 2 and 3 of the Genocide Convention, the Court demands fully conclusive evidence, which equates with the typical beyond any reasonable doubt standard of proof required in international and national criminal law. So in the case of Bosnia versus Serbia, the applicant complained with respect to the refusal of the respondent to reveal the content of some redacted sections of documents of the Serbian Supreme Defense Council, for the most part relating to the time of the Srebrenica massacre in July 1995. That is the only instance where the ICJ found that genocide has been committed. Serbia justifies such an attitude on two grounds: the classification of the said documents as military secrets, touching upon a matter of national security interest, and because it was so requested by some decision of ICSID trial chamber in the Milosevic case concerning protective measures pursuant to Rule 54bis of the ICTU Rules of Procedure and Evidence. It should be reminded that the order of no disclosure was issued on the basis of an application filed by the government of Serbia. The ICJ eschewed the core of the issue by observing that the applicant had extensive documentation and other evidence available, and that it had made ample use of it. In that way, the ICJ reaffirmed the soundness of the institution of arcana imperii, that is, the secrets of power, the state secrets that lies in the heart of the doctrine of raison d'etat. This position came as no surprise for those who know by heart the rules of evidence before the ICJ, but at the same time provoked their annoyance. It is well known that other international tribunals, like the Inter-American Court of Human Rights and the European Court of Human Rights, have opted less strict and less formal standard of proof, and even reversed the burden of proof in some cases of serious violations of human rights, like in the case of Article 3 of the European Convention concerning the prohibition of torture. Suffice to mention here the case of Selmouni versus France or Akun and others versus Turkey, related to allegations of the appellants that while being in custody, they suffered ill treatment and torture by police authorities. Such a practice is based on the principle that when state organs are accused of committing serious violations of human rights, they cannot wash their heads by simply denying the facts. In any case, it should be stressed that a high standard of proof adopted by the ICJ finds justification in international individual criminal responsibility facing incarceration, but not in international state responsibility, aiming only at declaratory and compensatory relief. On the other hand, in the case of Croatia versus Serbia, the ICJ found that in various localities, the JNA and Serb forces perpetrated against members of a protected group acts falling within subparagraphs A and B of Article 2 of Geneva Convention, and that the actus reus of genocide has been established. What is more, the ICJ also found that the crimes committed represent a pattern of conduct. Nevertheless, the ICJ dismissed Croatia's claim in its entirety, ruling that it failed to establish that the only reasonable inference that can be drawn from the established pattern of conduct consists in the intent to destroy the targeted group in whole or in part. So, how can be finally established that the state harbored a genocidal intent in the criminal set? It is just impossible. A state, like every other organization, can only develop a policy for the achievement of organizational goals. The organizational goal in the case of genocide would be the destruction in whole or in part of the national, ethical, racial, or religious group. The policy of genocide would consist in a pattern of widespread and systemic attack on the fundamental human rights of a targeted group, or even a collective pattern of violence. This was essentially the picture drawn every time an allegation was made that genocide has been committed. Hence, the ICJ could not determine the responsibility of either Serbia or Croatia for crimes committed, regardless of the fact that such state responsibility may exist simply because of the difficulty of ascribing specific intent to a state. And by way of a conclusion, I think that this situation, that position of the ICJ is due mainly to the fact that this court, while being an interstate court, is still anchored to the principles of ontological and methodological individualism. According to ontological individualism, only human beings are real and therefore possible agents. Organizations, even states, lack an autonomous reality. According to methodological individualism, all social facts must be explained exhaustively in terms of the actions, beliefs, and desires of individual human beings. However, both ontological and methodological individualism lead to normative individualism. However, the international community is not composed solely of individuals, but it also, if not primarily, is composed of states, corporations, and international organizations. In this context, if pluralism in its various connotations becomes an imperative for the normative reorientation of international justice institutions, then to deny the existence of state crimes will be to deprive ICJ of its ultimate end, namely the effective realization of justice. Thank you.
Thank you very much indeed, Athanasios. I'm sure we will come back to this during questions. It reveals a very interesting dilemma in the state-centered system of ours. Now, we've delved into the adjudication within various different judicial organs. What we're going to do next is to step back and appreciate, or rather take a more holistic view of the adjudication process. This will be Dalia's task. Dalia Balombo, who's a fellow here at Max Planck Institute, graduated from both Milan and then from the LLM program at Harvard. She is just about to finish her PhD, to be defending her PhD this coming spring, in which she looks into the responsibility of home states for grievous human rights violations committed by multinational corporations overseas, extraterritorially. So congratulations are, again, in order for that already beforehand. Now, indeed, what she will be doing now is to look at the human rights adjudication process in a more holistic way, in a title that certainly resonates with somebody who's grown up from a polity utopia. It says, between hope and debacle. So thank you.
Thank you very much. Thank you very much for the organizer of this conference, of course, to Professor Henry Srebri, and especially to Professor Lorenzo Grandoni, who has given me a lot of feedback on my initial proposal and paper. And as was said before, I'm a human rights person and human rights scholar. And this has been an opportunity for me to take a very different approach from the one I'm taking in my thesis, which is a normative approach, and to look at the human rights system for the first time from the outside. And I found this very interesting. So what my paper is talking about? Well, I think that the history of human rights could be defined as a cyclical history between hopes and debacles. And I'm going to try to analyze this history by looking, first of all, at very briefly what I think it's a bit the history of human rights, so the hopes and debacles that we witness, and then what human rights adjudications have done to answer to this challenge of debacles on the one hand, and to raise hope in people, community, and human rights victims. And then I'm going to just, in the end, decide whether human rights adjudication are doing a good thing in being so activist or not, and whether this is triggering in reality a new debacle. So let's look at the history here. As I said, I think the human rights system has raised lots of hopes. And what I believe is the main hope is that the human rights system is fundamentally a non-state-centric system, and is based on the idea that the person is at the center of international law. It's based on an anthropocentric idea. And this was how it was intended at the end of the Second World War, and I think the Universal Declaration of Human Rights reflect this kind of ideology. And I think this could be summarized in three main hopes. So the first hope is the hope for universal value. As I said, the idea in the Universal Declaration of Human Rights that there would be self-evident truth, that human rights are self-evident truth that are inherent in the human person. And so they would be obviously universal everywhere. The second big hope is the global reach of human rights. The idea that if human rights are universal, and if we have to say never again because human rights are inherent in the person, then human rights are applicable everywhere, and they have a global reach, and we don't need territorial limits to human rights. We don't need to have them. And the third brief hope is that given that human rights are based on the person, they're not applicable only against states, but they can be applicable in any relationship between states or non-state actors. And so that's what it can be called the horizontal application of human rights. And it's very interesting to note that when the Universal Declaration was established, it was very closely connected, this idea of human rights, with the idea of international criminal law that then developed as a completely different framework, of course, but with the clear idea that you don't need a state to violate fundamental values. Also a person, also a non-state actor can violate fundamental values. However, despite these three main hopes that the human rights system raised, there have been also lots of debacles. And I think the main debacle is that despite this hope to have an anthropocentric system, the current human rights system is very much state-centric based. We haven't realized what the Universal Declaration wanted to do. We haven't got to anthropocentric system. We are still in an idea where states are the main actors of international law. And this has reflected in what I would summarize as three main debacles. The first one, it doesn't work anymore. I don't. OK, sorry. The first one is the fragmentation of the international legal system. So yeah, we said the idea is that we have universal values that are inherent in the human person, but the reality is that international law is extremely fragmented, and not only the general international law, but the human rights systems are extremely fragmented. So that was obviously, with the big division between International Covenant on Civil and Political Rights and International Covenant on Economic and Social and Cultural Rights, right after the Universal Declaration have been signed. But it's obvious also now, the UN treaty bodies are 10. All of them focus on different types of human rights. And then we have the regional system, the free regional system, and we have many other areas of the world where there is no regional human rights system at all. So it's very clear that this idea of universal values, as it was said at the beginning, is not yet there, right? We have very different perception of human rights. They're clearly not universal. The second debacle is the treaties with territorial reach. So as I just mentioned, that human rights are embedded in a state-centric system. That means the states have to agree to a human rights treaty, and therefore these human rights treaties are applicable only within the territory of the states that have agreed to comply with them. And that means that despite the idea that human rights, given the universality should have a global reach, in reality they have a very territorial and limited reach. So that means essentially the European Convention on Human Rights is applicable only in those states that sign it, and so on and so forth for each convention. So let's say the Lauterpacht idea to create an enforcement global mechanism for the Universal Declaration of Human Rights is not there yet, and we don't know if will ever be. And then the third big debacle is the vertical application of human rights law. So despite the idea that human rights should be always applicable among any actor, state or non-states, the reality is that because we have a state-centric system, we have only enforcement mechanism against states. So human rights victims can bring complaints only against states and only against those states that have agreed to sign a particular treaty. And although the horizontal application of human rights is an interesting concept and is very well discussed by the doctrine, there are no enforcement mechanisms at the global scale. So what I'm trying to look at in my paper is how human rights adjudication have reacted to these huge challenges. And I think what they have done is that they basically try to extend their jurisdiction as much as they could. And I think there are three main ways in which I can see this extension. The first way is the extending the jurisdiction ratione materia. So meaning they have extended the human rights list and the obligation the states have agreed to. So it's obviously very famous, the notion of living instrument of the European Convention on Human Rights. This basically have included a new sets of rights in its convention. So although at the beginning it was thought as a convention based on civil and political rights mostly, we now see that, for example, environmental rights, health rights, reproductive rights are part of the European Convention on Human Rights because of this progressive interpretation by the European Court of Human Rights. The Inter-American Court of Human Rights have followed a similar path, by enlarging the list of jus cogens rights. For example, right of effective remedy became a jus cogens right in some of the case law. Another way to enlarge their jurisdiction is the ratione loci. So these have created what is now a very hot topic, and I discuss it a lot in my thesis, the extraterritorial reach of human rights treaty, which in itself it's a little bit controversial, because if human rights are universal, why do we need an extraterritorial reach of human rights treaties? Human rights should be applicable everywhere. So here the idea is that human rights are applicable only in one territory, the territory of those states that have agreed with human rights, and so we need an extraterritorial application of those human rights to foreign territories. There are a number of scholars that have engaged with this. And for example, the UN treaty bodies have a very progressive interpretation of extraterritoriality. The European Convention on Human Rights, that has first had a limited interpretation of extraterritoriality, is now enlarging it case after case. So it's interesting to see how this will develop. And the third way to enlarge the jurisdiction is ratione personae. So as I said before, obviously, human rights treaties are applicable only against states, and human rights victims can file complaints only against states in different regional tribunals or at the UN treaty bodies. However, to overcome this problem, what human rights adjudications have done is to establish this concept of positive obligations. And through this concept, basically, states become indirectly responsible for the violation of human rights committed by non-state actors. Of course, the states are not directly responsible for this human rights violation. They are responsible only for their failure to prevent non-state actors from abusing human rights or to provide effective remedies to human rights victims against those state actors. But this is clearly a way to push the boundaries of the state's obligation and to include also the responsibility of non-state actors somehow. So my final question is it good or bad? Is this raising new hope for the human rights system, or is it triggering new debacles? And I don't have an answer to this. I think we can look at this at two different ways. For sure, I think this activist approach and progressive approach of human rights court have raised hopes, and have certainly promoted the human rights system. And I give two reasons for that. The first one is what Harold Koch called the transnational legal process. So now, in a more than ever globalized world, we have a number of actors that are able to assess international courts and tribunals, including human rights courts. And there is an increasing activism from the victim side, from NGOs, as never before. And I would say that this has been developed from both sides. On the one hand, human rights courts have welcomed this kind of complaints, and on the other hand, these activists have kept going to human rights court, and there's been an enormous enthusiasm to do this. So this is certainly a reason for hope. Another big reason for hope is what Eyal Benvenisti has called states as trustees of humanity, his theory, which I find very interesting, that basically says that in a more than ever globalized world, states are not only responsible for their own citizens, but they are trustees of the whole humanity. And to a certain extent, what this is saying, I think an interpretation of this could be, if states want to keep a state-centric system, despite the fact that the system is much more broadened and we have much more actors in state, well, they should pay for it. And they should become not only trustees of their own citizens, but trustees of the whole humanity, of everybody they are able to influence. However, we can look at this also from the side of the debacles. Well, what happened is that it's true that it's good that victims get involved and activists get involved, but on the other hand, if human rights are becoming an instrument of victims, an instrument of NGO, then they're perceived as politicized. They're no longer those universal, untouchable values that we can look up to give us, a guide. No longer, because they are a political instrument, and so they can be used for the good or for the bad. And therefore, I think this attitude has to a certain extent delegitimize the concept of human rights. And the other phenomenon that we're seeing, I think, very clearly is the retreating from human rights treaties. I think a very good example of this, and I give only one, but there are many, are the non-refoulement cases. According to the non-refoulement principle, State A cannot send a criminal to State B if in State B this criminal could be possibly persecuted. Well, there have been some cases in the UK concerning terrorist suspects that were coming from Arab countries that have been suspected of bringing a threat to the UK, and the UK wanted to send them back to their own country, but it couldn't because of the non-refoulement principle. And therefore, what the UK had to do is to pay for these prisoners and to detain them in their own prisons. And this can trigger an enormous debate in the UK as to whether or not it makes any sense to be part of a human rights system that is actually protecting the very people that want to threat the national security of the UK. The debate has been so vivid that the current Prime Minister of the UK, Theresa May, has even proposed to retreat from the European Convention on Human Rights. So maybe an activist approach can actually trigger a refusal of the human rights system in the long term when there are only some states, those states that want to be part of a human rights system, that would pay for it, while other states can still choose not to be part of it. So did I answer to the question? Not really. Are human rights hopes for future generation or a debacle for the future generation? I tend to think they're hope, but that's just because I'm a big optimist. So thank you very much for this.
Thank you very much, Delia, sitting firmly between hope and despair, as we do. Now, let us open the floor for questions, discussion. And I see there is already a question that was, already before Dalia was finished, there was a question looming there. So please, let's start from there and then move on.
Thank you very much. My name is Patrycja Grzebek. I'm from University of Warsaw, and I have few remarks and one question. Few remarks to the presentation of Michel Erpelding. I really liked your presentation about mixed commission, but I found your concluding remarks difficult to be in agreement with them. Why? For two reasons. Firstly, you said that the works of the and the heritage of the mixed commission is not known and is not described. I cannot agree because even when I just Google some basic literature in Poland, I found a few monographs and articles just devoted to this question. And I must also say that I do not know Polish scholars who is writing about human rights who is not referring to the heritage of the Upper Silesian Commission. And in fact, I would argue that it was well remembered after the Second World War because this was the reason why Poland and other countries were opposing to include any reference to minority rights in Universal Declaration of Human Rights. So if you see, for example, Universal Declaration, there is nothing about minority rights. This was also the Polish proposition, and Poland, in addition, still was afraid that this is too little, so that's why Poland was one of the few countries which abstained from the voting for the declaration. And then in 1966, where covenants were adopted, still many states, they framed very cautiously Article 27, remembering what were the results for Poland, taking into account not only mixed commission results, but also all cases in the Permanent Court of International Justice. And also I have a question to Dalia. Also, I found your presentation very interesting, but I have a question because you made an opposition between universal values and fragmentation, and I'm not sure if this is convincing because even if you have many different regimes, like regional regimes, universal regimes, if you find that there is a core, that there are some rights which are agreed in every regional system, this you can say that this doesn't contradict that we have those universal values. And also, I'm not talking about this territorial reach and extraterritorial reach because I'm totally in agreement with you, but with your final remark when you were discussing this vertical and horizontal result, I'm wondering, should we always count only on international law? Maybe the question of the horizontal effect should be just given to national criminal law, civil law system, that this could be dealt just on national level, not necessarily on international one, and this should not be considered as a failure, debacle, or whatever. Thank you.
There is one more. Let's take a number of questions. Gentlemen,
yeah,
yes.
Thank you very much. I enjoyed very much the whole panel, but I had questions, I think probably more for the first two papers. I think we are growing through a number of historical experiences with international adjudication. And in a way, it makes me think of the notion of Foucault of archive. In a way, what we're digging and reopening, in a way, is the archive of international adjudication, which doesn't mean that within that archive there is a variety of traditions and lines, in a way. I think, in a way, I mean, not in response, but in reaction to your point, I think, in a way, what is interesting is that this mixed commission didn't make it to the legal tradition of, the history of international, the official history in a way of international adjudication as, one step towards a more court-centered international law. But at the same time, I remember, in fact, from history books, that this was a part of the history of international relations, this mixed commission indeed. So in a way, it's about how within this archive, some historical experiences, actually fall into the legal tradition, and some others actually fall outside of this legal tradition. So that brings me to a question, because then who are the professionals, in a way, of that archive, or of that tradition, more precisely, that legal tradition? Probably, in a way, scholars are, because they are the perpetuators of a history of experiences, those who are considered to be forgettable or not forgettable. Those are to be deemed of interest for the history of progression of the idea of international law. So that brings me to Michel and Nicolas, sorry. Nicolas, because you were mentioning, indeed, that scholars, the failure, in a way, of the European Social, the committee of the Charter of the European Social Charter to interest scholars. And to Michel, the fact that you mentioned a lot Collander, but you don't tell us much about him. And in a way, what is critical in other cases I've been looking at, for example, is the capacity of these judges to relate to scholarly communities and raise the interest beyond the court. So who is he exactly? And can there be an explanation of the failure of this commission to interest that would be related to who he is, how scholarly connected he was or not?
Anyone? Yes, please. There. It was the second row. Yes. Great. Thank you.
Thank you. I also have a question to Dalia concerning fragmentation, taking up what has just been said. I am also not very much in agreement with the idea of a fragmented human rights world. And I think that a part of this actual harmony between different human rights systems lies in the role of international courts or quasi-judicial bodies, which are entrusted with ensuring compliance with different treaties, but at the same time interpret those treaties by looking at other bodies' case law and reading similar provisions in very similar ways and ensuring that there is an harmonization through judicial interpretation. I think this should not be forgotten. I also have a question to Michel. I was very interested by your presentation. I was wondering specifically about the role and the relationship between the Mixed Commission and the Permanent Court of International Justice, and more specifically this idea of indirect discrimination. We also find in the case law of the Permanent Court of the same years very clearly stated, for instance, in the advisory opinion on minority schools in Albania, which one came first, which one influenced the other, is there any influence between the two bodies or not? Thank you very much.
Thank you. Let's take one more right behind there. Professor Hirsch. Yeah.
To Dalia, I also enjoyed very much your presentation, and following this question I wanted to ask with regard to fragmentation. Beyond some core human rights which must be universal, is it realistic to expect that all regions of the world would have the same set of human rights? Africa, Europe, Latin America. I mean, do we really want to have one single rigid set of human rights enforced everywhere? I'm not so sure.
And there's one more, and then as the rest of you think of your questions, we'll have answers to the Vice President.
Thank you. My question draws upon the comment about fragmentation that has just been made, but I'm taking a slightly different perspective. Consider the normative traction that international human rights law creates in other specialist fields of international law. Upon infiltrating those fields, for example, through sources, doctrine, interpretive techniques, models of reasoning, if you consider the potential normative effects of human rights law in those fields, you'll see that basically this move could make it face some ideological and methodological resistance within those other fields. IHL, ICL, trade and investment law, for instance. So in your view, does this expansive logic of human rights law, something that Alain Pellet called droit de l'homisme some time ago, not create this dangerous pushback, making human rights law the victim of its own success? And also the second question that I had concerns the victim activism that Dalia mentioned in the presentation. I was wondering whether, in your view, the growth of international and transnational human rights litigation not detract attention and also draw valuable resources from other potential fora and mechanisms that may be more effective in terms of obtaining an effective remedy for human rights violations. Because the ideology and machinery of individual human rights, especially as they are conceptualized in the global north and in the west, may have a detrimental effect. It might marginalize other remedies, including community-based approaches, as opposed to the individualist approaches. So I was just curious to know what your thoughts on this are. Thank you.
Thank you. Now, let's have a round of answers. And I will invite, although Dalia was bombarded with questions about, naturally, with regard to the universalism versus fragmentation debate, I would invite all of you panelists to address this particular issue, if you wish. But Michel, let's start with you.
Oh, about
reply to, because you are bombarded with so many specific questions. You go ahead with those.
I've got lots of specific questions. I would like maybe to answer those first. With regard to Polish scholarship, I mean, I don't read Polish, so as a matter of fact, I apologize if I have offended Polish scholars here. What I wanted to say was there's nothing in mainstream international legal scholarship. This is a fact. If you look it up in the main languages of international law, which are still English and maybe French to some extent, there is nothing after Korowitz's book of 46. And Korowitz was a Pole, of course. Now, there are, of course, publications, monographs written by Poles and Germans, also in German, in international relations scholarship and by historians. There's also a book written by former Swiss ambassador to Poland, which was published in German and in Polish, which was very helpful also. And actually, the one recent publication, legal publication, I found, which was more mainstream publication, was written by the British legal historian, the late British historian A.W. Brian Simpson, and it came out in 2001, but it was hidden in a book that has over 1,000 pages, and it's a few pages only. So. And we contacted people in Katowice, and it took a long time to get answers. And then people were, they said, okay, the building is still extant, but it's actually not commemorated. And they knew about it. But the answer was, okay, it's interesting, but whereas people like Brian Simpson, this is really revolutionary. Well, was really, really relevant. And Korowitz said the same. And I haven't read anything like that by anybody else than Brian Simpson, or then you have to go back to Korowitz, to find something like that, at least in mainstream international legal scholarship. Now, with regard to Kolonda was a former Swiss Bundesrat, so federal president, during the Versailles peace negotiations. And they chose him because, he was a lawyer, and as I said, he was a good conciliator, apparently, and he was a member of a minority, of the Romansh minority. He was appreciated by the minorities in Upper Silesia, although at some point the Polish side tended to say, well, he's a formalist because they suspected him of being slightly more pro-German, but then he showed that he often showed that he was as critical of the Germans as of the Poles, notably with regard to the Jews, but also with regard to the Poles living in German Upper Silesia. And the people of Upper Silesia even called the tribunal the Kalondas Tribunal. That was the popular name of the tribunal, which shows that it was really, it was one person tribunal, because he was the only one who had jurisdiction to give these opinions, and that was also one of the reasons of the overload of the tribunal. And later, after Upper Silesia, Kalonda went back to Switzerland, where he worked in private law practice, I think in an insurance company, even together with Guggenheim. Yeah, so that was his background. As with regard to the PCIJ, there were many relations between the Mixed Commission and the PCIJ, also procedurally. Honestly, I don't know with regard to indirect discrimination. I would have to look it up. But I know that, for instance, with regard to the minority school access, the PCIJ didn't really have the same position as Kalonda. Kalonda said, well, people can choose whether they're part of a minority or not, and they can choose whether their children are or not, whereas that was what Kalonda said, maybe also from his personal experience. And the PCIJ said, well, there needs to be some kind of language test, and then they instituted some kind of language test, and Kalonda supervised it, actually. And they brought somebody in from Switzerland testing whether the Polish children actually spoke German or not, whether it would be entitled to go to German minority schools, because actually many wanted to go there because they thought that socially would give them a better future than going to Polish schools, which of course the Poles were not happy with. So.
Nicola.
Okay, then briefly on fragmentation. Now, I think regarding the experience of the European Social Charter in relation to the European Union, the issue of fragmentation there is really against another specialized system. And here the dominant one is clearly the European Union. And the values, the liberal economic values are the ones who dominate the view, to the point that the social rights are hidden, to the point that the European Court of Justice decides not to deal with the issue when it's asked the question, are the measures compatible with the Charter, the Fundamental Charter of Fundamental Freedoms, which obviously inside the Charter there are mentions of social rights. So my view would be that the major conflict is between specialized regime, not so much from the point of view of social rights between regions or systems within the human rights field.
Okay, so I'm going to try to give an answer on universalism and fragmentation that hopefully answer to all of you. I'm not sure. So the first thing I want to say, I talk about universalism and fragmentation by comparison between the original idea of human rights and, for example, what Lauterbach first thought about the human rights system when we were talking about the Universal Declaration of Human Rights, when we were talking, where people were thinking about a universally enforcement mechanism, and of all the attempts that there have been in history after to create a World Court of Human Rights, and the current actual regime where we have different human rights tribunals, different human rights treaty bodies, regional courts. So that's what I'm discussing. I'm not discussing the definition of universalism and the definition of fragmentation in the absolute. That said, I agree with all of you that, of course, human rights, there is a core of human rights that we can find in different treaties. And of course, I mean, I haven't discussed this in these 15 minutes, but in my paper I also talk about jus cogens rights that are, by definition, the exception to this fragmentation, because they are the same. But the problem is that even if you think about these core human rights, they are interpreted by different international courts. And we know that for the same human right, there can be 10 different interpretations. And then they have to be implemented in national courts, and that goes back to also to the horizontal application questions, that have to provide these effective remedies to victims against other non-state actors. So as a result, it's very clear that the interpretation of the same right can be very different in different systems and in different countries. And that's why I'm saying that I think we have a human rights fragmented system, although the idea, the first premise was to have a universal system. To Professor Kirsch, it's a very good question. I don't think it's realistic to have one human rights system for all the regions of the world. If I think it would be a good thing, I do. But this is personal. I do think it would be a good thing. I don't think it's realistic. I think that the idea of human rights is they are inherent in the human person, and therefore I find very hard to say, for example, women's rights are rights only in some parts of the world and not in others. I personally find it very hard, but I don't have a definitive answer, and I know it's unrealistic. And this is one of the reasons why I'm studying this topic, because I'm interested to find out more. So thank you so much for your question. On victim activism, is this taking resources away? Where would you put the resources otherwise? I'm curious to know this, because I understand that the system is not working maybe as we wish, but I see it as the only system at the international level that we have. We could have systems at the national level that are better placed than human rights system. However, when this system at the national level fails for various reasons, the only system that the victims currently have at the international level is this one. So it would be interesting to see what are the alternatives that you're thinking about when you say putting resources away. I think that if victims look at the human rights system, it's probably because they don't have other options. Because if they would have other options that would be easily available in their national system, they would just not go to the international one. But that's just my take on it. Thank you.
No? No? Okay, pass. Please.
It's my turn?
Yes, it's your turn.
Okay, I'm really happy to have the chance to talk about this. This issue of fragmentation and universalism, because I listen to the questions from all of you. They sound to me like very technical, and then I remember what I read in the archives, and I see cognitive dissonance here. We're not talking about the same thing, and I have 4 things to say about that issue. It's the first thing, the view from the archives in 1945 to up until mid-60s, human rights is not about protecting the individual. It's about constructing a specific set of authority, which has the shape of a state, of a modern state. And it happened to be, from the American perspective, this state cannot be communist or socialist. It has to be liberal and democratic. And so human rights first is about building a specific set of authorities and how this authority is distributed among people. The second thing, the issue about universalism, I have this quote in my work. It's the personal counsel is Sandifer. Durward Sandifer is the personal counsel of Eleanor Roosevelt in 1948, December 1948, probably 2-3 days after the adoption of the Universal Declaration. And he said something like, oh, we're all really happy in the American administration because the Universal Declaration is a carbon copy and is in the archives, a carbon copy of the American Bill of Rights. So what are we exactly talking about when we're talking about universal human rights? This is a really, really good question. And my humble opinion on this is that we have, the Americans succeeded in universalizing American ideas about human rights. So we're really talking about universal human rights today, but they have like a very specific origin. I think, in my opinion, if we ground the system on the Universal Declaration of Human Rights. And the third thing I want to say is about thinking about human rights was thinking about a specific type of future, not about constructing a specific type of state, but it's about constructing a specific type of values and economic structure. And it was really important. That's why, for instance, economic social rights appear at the end of the declaration. And for the American, it was obvious. And there are discussions among top lawyers, Philip Jessup, Charles Fahey, Durward Sandifer, Eleanor Roosevelt even was involved in the debate. we need unemployment for capitalism to survive. We need at least 4 or 5% of unemployment. That was in the debate in 1945, 1946, 1947. You have captain industries in the US claiming and arguing for unemployment. Discussion about right to work revolve around whether we have a right to work, the communist position, or whether we have a right to work, which was the Western Europe and US position. And right to work means you have the right to work, and you have the right as well to be laid off. And so it's about human rights. It's also about constructing a specific type of economic relationship in the post-World War. And the last thing about fragmentation, I have a bunch of letters of exchange between Philip Jessup and Hirsch Lauterpacht. Lauterpacht's complaining, whining, crying in these personal letters he wrote to Philip Jessup, which you can find in the Library of Congress in DC. And he complained, and Jessup agreed with him. But American strategy was about fragmenting the system, because if you fragment the system, you weaken it. And if you weaken it, the better we are. And that was really, really clear from the outset that it was a strategy. And if you look at the archives of the Geneva Convention 1949, the UDHR, the Universal Declaration 48, if you look at debates on self-determination and the Human Rights Covenant in 1966, and there's a forthcoming book by Marco Durante, an historian based in Australia, arguing that the European human rights system was a conservative project aimed at defending Christian and anti-communist values. And so it's really important to think about these things, not necessarily in the terms of universalism and fragmentation, but to think first, why are we using this vocabulary to talk about these issues? Because if you look at the history, if you look at the documents, we have a radically different story in the history to tell, and that's my point.
And that brought us back to the social sources of rights, something that we discussed earlier. Now, a few more questions? And then we'll really have to wrap up. Yes, please. Thank you.
Thank you very much, all of you. Very interesting presentations. I think this is a wonderful panel. My question is directed to Dr. Juliaras. I'm sorry about the pronunciation. It's going to be a technical question, I'm afraid. As far as I understood, and please correct me if I'm wrong, you criticized the ICJ for its adoption of criminal law standards to questions of state responsibility. And you single out the issues like burden of proof or the criminal intent. I'm wondering, is this really what the ICJ did in the Bosnian genocide cases? And this relates to the notion of attribution. I think that's the key word here, which I found surprisingly missing from your presentation. I thought that genocide case was about state responsibility, not in isolation, in the abstract, but in connection to an international crime committed by a natural person. Proof and intent, therefore, need to be shown only to be present on the part of the individual, not on the part of the state. So I was wondering, what is your take on this maybe alternative reading of Bosnian genocide? And another question related to that, why did you leave out the issue of attribution? Thank you very much.
And anyone else? If not, there you go, please.
Well, actually, I didn't use the term attribution, but I was talking about attribution. I mean, is it necessary to use the term? I mean, the question was whether these crimes committed in a specific area could be attributed to a state. And actually, mostly in the second case of Croatia versus Serbia, that claim was rejected by the ICJ only because they couldn't establish the genocidal intent of the state. I mean, I think that this is impossible to establish. Of course, they make a very brief allusion to the issue of state policy by saying that both states accept that genocide requires a state policy. But if we don't have this state policy, other ways to establish that is by inference, and they use all these issues. So why don't we talk about the state policy? Because this is, one of the crucial issues in the field of international criminal law as well, whether the state policy is an element of core international crimes in the case of individual criminal responsibility as well. And the most problematic, of course, case is the case of genocide, where you don't have a contextual actual element, but you only have this reference to intent. So I think that because I'm not interested so much in the actual result, whether that can attribute it or not, but I'm interested in the means employed by the court to reach a conclusion. And I think that using this kind of categories and concepts, you can't reach such a conclusion because it is impossible. And it is very frustrating, in my opinion, that after 16 years, because this case lasted 16 years, we read all these pages. I mean, for me, it was a loss of time, and mostly it was a failure to deliver justice to victims, because, you know, all these very respectful scholars and judges should extend their knowledge and read other things like sociology of organizations, organizational theory, discursive analysis, where they can find elements to address a corporate action and organizational responsibility. They can do it when they want. For example, in the case of international criminal tribunals, they have developed these new modes of liability that, according to the critiques, put pressure to fundamental principles of criminal law, national and international. So there you have individual attribution of a collective contact, and maybe you have this class with these basic principles of individual accountability, for example. In the case of the state, why you should look for intent and not for a goal, for example? Because this is what in the decade of the 60s and 70s was developed in the organizational theory, the goals theory. So I don't see the word goal in there. I mean in the decision. I don't see the word policy. I see the word pattern of conduct. But afterwards, this pattern of conduct should lead to the genocidal intent. So, and I think that this is something that can give any credible result.
No, thank you very much, Athanasius. With that, we've reached the conclusion of the panel. We've been sailing between the apology and utopia, if you will, the hope and despair. We've looked into the site that provides us hope, makes demands, and the world demands a better, brighter, just world. The ones that are apolitical, ahistorical rights that are universal, we hope. And we've looked into the site that stands firmly in the constitutions and conventions, negotiated, compromised, representing only the views of those who were around the table to discuss the rights to begin with. And in a sense, we've also looked at the despair and the loss of hope that so often comes when adjudicative bodies begin to do what they do every day, and rights become banalized, just business as usual, and before you know, meetings will be when well-dressed women behind addressed each other from piles of paper and talk about issues like per diems and where the next meeting is going to be held. But here's the thing, rights never lose that critical potential that they have, and you know it. To say that this is my right, you know that intuitively, it is different than from saying that this is in my interest or please. And with that, ladies and gentlemen, let us go and have some coffee.